Good Thursday night. I am Thabo Mdluli. Good to be with you tonight on In Focus. Let's start here now. The Constitutional Court has dismissed the Correctional Services Department's bid to appeal a prior ruling which ordered former President Jacob Zuma to return to prison. The Braamfontein Court found that there's no reasonable prospect of success but declined to award costs and prison boss Makoti Tobakhale approached the High Court to challenge the judgment. Zuma was sentenced to 15 months behind bars for contempt of court after refusing to testify at the state capture inquiry. But the former president only served 2 months of his prison sentence before being released on medical parole by the then Commissioner Arthur Fraser. Groups like the Democratic Alliance and the Helen Suzman Foundation then successfully challenged the decision in the Supreme Court of Appeal. Still in our courts, President Cyril Ramaphosa has welcomed the Constitutional Court's decision upholding Advocate Busisiwe Mkhwebane's suspension as the public protector. Deputy Chief Justice Mandisa Maya found that Ramaphosa had nothing to gain by suspending her. This is despite Mkhwebane claiming that it related to an investigation into the Phala Phala farm theft. The court found that the probe into foreign currency stolen from the president's farm continued despite Mkhwebane's absence. It further ruled that the mere fact that Ramaphosa was being investigated didn't present a conflict of interest and that he was simply exercising his official duties. Mkhwebane is currently facing a parliamentary committee, Section 194, into her fitness to hold office. She joins us now for reaction to the judgment. Advocate Mkhwebane, good evening. Good to have you, and thank you very much for your time.
Good evening, Thabo. Good evening to your viewers and listeners.
So the whole matter, I'm sure you would know, I don't have to remind you, emanates, of course, from the High Court ruling in the Western Cape, but where you went to seek, amongst other things, that the conduct and the decision of the Speaker, the conduct of the President and the conduct of the Section 194 Committee be deemed irrational, unconstitutional, and invalid. That court at least found on the question of conflict of interest that the President certainly could have been conflicted there. But today, of course, that particular decision has been reversed. How do you feel?
As I said, Thabo, that I was expecting this, especially the comments which were coming from the public about our judiciary and some of the judges, and also what the late Tina Jumaat-Peterson said, that the courts are with Ramaphosa in the recordings which we shared with members of the media. Unfortunately, no one played them. But I was expecting this because it's as if, the other arms of the state, the judiciary and the legislature, cannot hold the president to account. Holding the president to account helps our democracy, helps as well that the president should know that they should be operating within the parameters of the Constitution. So I was not surprised, and I was expecting this negative judgment.
So especially the grounds that you relied on, at least as far as the president is concerned, and the one of conflict of interest coming into question. Do you think you could have misinterpreted their sections of the Constitution and what they mean as far as the work that relates maybe to Parliament, the work that relates to the committee, the work that relates to the Speaker, and what would have constituted conflict of interest with the President, considering the timelines and how things played out?
Maybe let me say we worked with the Thabo. It means the 3 judges, the full bench of the Western Cape High Court, the way they've pronounced on the judgment, the ulterior motives, vindictiveness, and now the president dealt with me, especially after sending those questions to him. He couldn't even wait a day before the Western Cape High Court delivered their judgment on the issue of Part A. And it's even worse because we were saying he's even violated, or it was like interfering with or like contempt of court in terms of Section 65 of the Constitution. So the issue of conflict, he was conflicted on a number of investigations which are conducted. He even acknowledged himself during the Busasa matter that he's still conflicted because the matter is before court. But worse still, remember that the investigation was ongoing. And I mean, the judgment is saying the president was within his right to suspend because of the issue of the integrity to the office, and for me to have time to prepare for my defense. Forgetting that the very same president refused to, kind of step aside, or as well in his responses when the Section 89 inquiry on him or the report, there was issue that no, the public protector is investigating or so and so, and you're still in the office as that particular person. Where have you seen it where a police is investigating a matter against a person who has the power to suspend that particular police, and the police is suspended? So it means the Constitutional Court says there's nothing wrong in that. So it's an issue which is very concerning, actually.
Yeah. The court saying the president did not know when he took the decision to suspend you that the High Court was going to deliver a judgment on a Part A matter on the following day, saying these things is not something that the president knew and therefore made a decision to suspend you.
It's not true. I think unfortunately, they are hell-bent in believing whatever the papers of the president are saying. We also showed that there were communication between my legal team, the president's legal team, where they even committed that before the president goes ahead, because the matter was still before court, they would indeed inform my legal team about the president proceeding with the matter. And secondly, the issue of the judgment that it will be delivered the following day, that was sent to all the parties. Yeah. I don't understand when they say the president didn't know. The legal representation of the president should have known. And then another concerning issue is that the president was supposed to at least have informed the legal team that I am proceeding with the matter, or sending an information that I would want to deliver this particular decision. Why wait until you receive the questions? Why wait until the judgment, or even a day before the judgment is delivered? So I don't think it's true what has been put before the court, because at the end of the day, the president was indeed aware. And what's worse also is that Section 194 says the president may suspend at the beginning of the proceedings of Parliament. So the beginning of the proceedings only started in July, because that's when the proceedings started. Possibly, if the president also waited for the proceedings to start, then we would say the president was possibly within his right to
so,
do
I mean, for example, for something like that, that is quite key, because the judgment says that the Section 104 committee proceedings had already started by the 9th of June when the president suspended you.
That's not true. They haven't started. The evidence leaders were not appointed. But besides, the the proceedings were not yet in full force, and I think those dates we can even clearly show. But my issue, Thabo, is that the president was under no pressure to. I mean, if they are saying that, it means if they say the proceedings started already, because already in March, Mapisa Ngagula wrote to the president indicating that now they've finished with the process. There's the judgment of the Constitutional Court where the issue of the rules was deliberated on. So by then, he didn't act. The fact of the matter is that the suspension was based on the fact that it was vindictive per the 3 judges. And it's even worse, those 3 judges, they delivered the judgment and we were exercising our rights. The Section 18 application was based on the fact that whilst the matter is still being appealed on, one should return to work, and was clawback with personal costs. Why that is happening? They said judges who agreed with our arguments then, nothing is happening to them. It's very concerning that the highest court can also deal with this matter the way they dealt with. So,
okay, we can argue that case. In fact, what the court are saying there, they are saying that it may well be asked, as you're putting it, why did the president not wait for the impending court judgment which sought to restrain him from suspending the public protector and which would have judicially determined, albeit on an interim basis, the lawfulness of the very decision he was about to make. But when confronted with this question during the oral argument in this court, his counsel, in his words, considered that the optics are awkward. Not to wait for the imminent judgment could be seen as imprudent and show a lack of caution on the part of the president. But, whatever the case, that is not the legal test on the High Court's reasoning. Is wrong. That's what they are arguing.
I would say that that's what they would argue, Thabo, but at any rate, the judgment, and they feel that the president didn't act vindictive per the Western Cape 3 judges' judgments. So that's all what we can say. It's fine for them for the president to conduct himself the way he conducted himself. So at the end of the day, that's what I said. That's what I was expecting. And then there's nothing more one can do because that's the highest court, the court.
Do you think you should have allowed those 31 questions to be submitted in the High Court? Why did you not allow them to be submitted?
What?
The 31 questions on Palapala.
Remember, it's not me. I was suspended already, and it's so strange why. Remember, there was the president's legal team submitted that letter to the court that the public protector, the acting, has allowed them not to disclose those particular questions and the responses. So remember, I was already out. I was already suspended when the matter was deliberated on in court.
Right. So you're saying that was part of, I suppose, of a bigger plan to conceal something?
Yes, because at the end of the day, remember, even the DA and the president's legal team who advocate Batlender, remember, was even saying if the Constitutional Court maybe decide that I must return back to work, I must not touch the Palapala investigation. He said that clearly, and they didn't want me to be involved in this. And strangely, Thabo, now 8 months down the line, what were they doing? We've submitted a complaint to the JSC because the West, they could have taken at least 6 months, 8 months, and not delivering the judgment. So I hope the Judicial Service Commission will have to deal with the matter, and they must account as much as they managed to say Judge Maumela and Kobisa must be suspended for failing to deal with or deliver the judgment on time. But with me as well, the issue of delaying to issue judgments, It's similar to the CX or South African Reserve Bank matter. They took 9 months to deliver the judgment, and they came back with personal costs. Strangely, even this one, they take 8 months. So fortunately, we've lodged the complaint. One will have to see then how the matter will be dealt with, and objectively so. Why did they delay to deliver the judgment?
Yeah. Any thoughts of a rescission application of the decision of the ConCourt?
We haven't considered that, but at the end of the day, our focus now, Thabo, is the Section 194 committee. Remember, I said we've submitted the application for recusal of the chairperson for the 4 or 5 grounds we've mentioned, which is the key is corruption and bribery, and also one of the committee members, late Dina Jumat Peterson, who also met with my husband and solicited the bribe on behalf of herself and Janji. And I mean, the recordings, Janji and Majodina are mentioned more than 5 times, indicating about their anger, not getting ministerial positions, and Janji wanting to come out. So that's why we even shared I even shared the recusal application.
Yeah.
Members of the public can read that on my Twitter page, Twitter handle, so that you can understand why we're requesting the recusal of Mr. Janji.
And at this particular point, how far is that investigation with the Hawks?
The Hawks are busy investigating. It would help as well to check with them. But remember as well, there was that announcement that it's not only now the extortion and the issue of bribery. Remember, they also will be investigating the issue of inquest, the circumstances surrounding the passing on of the late Dina Jumat Peterson, and that then it might reveal other things. So we have a chairperson and the ANC and the committee, which doesn't even care that one of their members has passed on. They just want to continue as if nothing is happening, and there are serious allegations. Whereas the ethics committee even removed the members who are serving in the Section 194 committee, realizing that they are also members who might be tainted by this particular issue. Therefore, they wanted to deliberate on the matter away from these members. But now he is refusing to recuse himself voluntarily. Finally, we've submitted that recusal application, and it took so long because I didn't have the senior counsel, and we've been asking the state attorney and the public protector office to give us a go-ahead to brief counsel only to lodge the application for recusal, because I cannot appear before the chairperson who's conflicted.
Advocate Mkhwebane, I appreciate your time. Thanks so much for coming on tonight. That's the suspended public protector, Advocate Busisiwe Mkhwebane, saying now their focus tends to the Section 194 committee.